My name is Paulo Barroso, and I am the director of this lecture series in the name of my colleagues Dean Vince Surgio of the Law School and Professor Vlad Perdue of the Clough Center for the Study of Constitutional Democracy. I'm delighted to welcome you to today's Distinguished Lecture in Jurisprudence. Our Jurisprudence series is a joint initiative of the Law School and the Clough Center here at Boston College, and it aspires to be and is quickly becoming a leading forum globally for the presentation debate of demanding, plural, and imaginative work in jurisprudence that confronts the challenges of our time. Past Clough Distinguished Lectures have included thinkers such as Amartya Sen, Kim Chappell, John Finnis, Robert Pippin, Nicola Lacey, Jeremy Waldron, Matthias Kuhn, Fred Schauer, Christina Lafont, Ren Herschel, Tommy Shelby, Robert George, Alice Wistrop, David Garland, Shona Schifrin, Jürgen Habermas, and Roberto Unger. Our distinguished lecturer today, Frank Michelman, is a Robert Walmsley University Professor at Harvard University and a fellow of the American Academy of Arts and Sciences. He was a past president of the American Society for Political and Legal Philosophy and has authored some of the canonical works of jurisprudence and constitutional theory of the last few decades. If you're looking for examples of what intellectual greatness in law might look like, you would be well advised to turn to Professor Michelman's scholarship. In a time when legal education is besieged by intellectual minimalism and by what one might call practicism, it is indeed a happy occasion when we are able to listen to Frank Michelman. If legal education survives as such, and in, say, 200 years from now, jurists and students of law are still interested in legal humanism and want to know how it looked like at the beginning of the 21st century, they would be well advised to turn to the work of Frank Michelman. So it is with great pleasure that I give you Professor Frank Michelman.
Thank you, Paulo, for that very generous introduction. And thanks to Professor Perdue and the Center for inviting me to come and talk to you. And thank you all for being here. And we'll get started with constitutional rights and human rights. I think that's what we call this. And we'll begin with constitutional rights. People argue over what to do about them. We argue over whether this or that constitutional right is or would be a good thing to have as a part of our laws. We do so without much of a doubt that we have something real to argue about. And that last is not so clearly the case with talk about human rights, where doubts can sometimes hang heavy about whether there actually are such things in the world at all. Of course, many people do quite firmly believe in a strong reality of human rights. In fact, it's a reality so strong that it precedes and transcends any mere facts you might report about a given society's actual laws in force. The existence of a human right against torture, you will think, does not await the creation of laws against torture. It rather demands their creation. So suppose that you are a believer in human rights. And suppose you find yourself in a position where you can exert some measure of control over what goes into the constitutional laws of your country. Would you not then be morally bound to conduct yourself towards the end of bringing your own country's laws into the closest achievable alignment with the truth about human rights in which you committedly believe? How could you not make that your aim? That's going to be my question here. I want to ask about reasons you might possibly have for rejecting an aim of conforming your own Constitution's Bill of Rights, its chapter on rights, to the truth about human rights. And here I don't just mean setting that aim aside as too difficult or distracting to pursue in present conditions of knowledge or of politics. I mean actively rejecting that aim as morally misguided, as antithetical to some value or values that you rank ahead of it. Okay, I'm soon going to turn my question into a kind of a story that we can all try to think through or play together. It will help, though, in moving the story along if I take some time at the start to lay down one definitional stipulation. I define a distinction between institutional rights and pre-institutional rights. A right isn't, this is going to boggle the mind a little bit because I'm not going to give you a definition of a right here, only of what makes a right institutional or pre-institutional. You can figure out for yourself what a right is, and once you know, you can report it to me so that I will finally know. A right is an institutional right when the ground of its recognition as a right is an observable action or declaration by some established institutional authority. If I ask you whether I, as I stand here, have a right to Medicare, you, I expect, will answer yes, if you know how old I am. If I ask you what you base that on, I'm pretty sure you will refer me to certain acts of the American Congress. You instinctively think of my Medicare right as an institutional right. A right is a pre-institutional right when the ground of its recognition as a right is not any observable action or declaration by an institution. If I ask you whether, as I stand here, I have a right not to be tortured, you answer yes. If I ask you what you base that on, I'm not sure your first answer will be to refer me to some statute or even to some treaty. You will more likely first think of a right against torture as something that everyone simply has, regardless of what any political lawmakers may or may not ever say about it. You thus think of my right against torture as pre-institutional, as a moral right, as it would often be called. Okay, now we're ready to set up our story. So let's say we have a good friend, and I'm going to call her by the name of Justitia. Justitia is about to start a term of service as a member of a constitutional convention in her country. The convention has been duly authorized to prepare for eventual submission to a national plebiscite, as thoroughly revised a constitution for this country as the convention may see fit to submit. It's an unlimited constitutional convention. And let's assume the country is solidly anchored as a broadly speaking liberal constitutional democracy and is doubtless going to remain in that general orbit. So who are we? We are a small circle of learned friends whom Justitia has invited to consult with her over drinks and dinner about how she ought to conduct her service at the convention. She starts out the conversation by stating it as her present firm intention to work as hard as she can to achieve as close a fit as possible between the new Constitution's chapter on rights and the true roster, that's what she says, the true roster of human rights. She wants our responses, our reactions to that idea, and the objections start to fly. So this is the game part. You're all part of this dinner, and although I'm not actually asking you to speak up now like it's a classroom, you probably, you'll be free to later. What I'd like you to do is sort of think along with me. You've just heard what she's going to do. She's going to go to the Constitutional Convention, and she's going to try to, every time there's a vote or she makes a speech or whatsoever, she's going to try to push the enumeration of Bill of Rights of this Constitution in the direction of what she calls the true roster of human rights. So our first counselor stands up and he immediately protests that a constitution for a democracy ought not to contain any declaration of rights at all. It ought to trust the democracy. It ought not to lay down in advance any constraint on the outcomes from democratic politics if it's a democracy, or at any rate no constraint that would extend beyond a very narrow set of political rights, say the right to vote, that would fall short of any list of human rights in the sense he's sure Justitia has in mind. Justitia just bats that objection away. She knows those debates, she says, and she comes out the other way. In order even to be a democracy, she says, a political regime would have to be committed to a due regard for the equal basic rights of persons as bearers of human dignity, as required to assure their independence, and so on. Justitia, you see, has been reading Ronald Dworkin. She's coming down in favor of what has been called a substantive conception of democracy as opposed to a purely procedural conception. Okay, says our first objector, I get that. The problem, though, is about putting those rights into a constitution. When you do that, you thereby inevitably hand over too much power to judges sitting in law courts to run the country's affairs. No, answers Justitia, that's not necessarily so. We can lay down requirements as constitutional law, meaning thereby to place our lawmakers and officials under corresponding duties of fidelity and compliance, without necessarily making law courts the final arbiters of compliance or the lack of it. You know, the people voting at the next election, maybe they can decide whether the lawmakers have been compliant with the Constitution. So Justitia is in a way giving credence to a set of ideas that circulate these days under banners of political constitutionalism or popular constitutionalism. Well, second counselor now steps to the plate, and this one denounces as illicit any project, he says, any project of aligning our country's constitutional laws with human rights as laid out in instruments like, say, the Universal Declaration of Human Rights or the International Covenant on Civil and Political Rights. That's illicit, he says, because the international bodies that presume to issue those directions to the world simply lack any sort of legitimate institutional authority over us that requires our attention when we're making our own laws. Where do they get off telling us what to do? Justitia is unfazed. You haven't quite understood me, she says. When I speak of human rights, I mean a body of rights that is pre-institutional. It's human rights as moral rights with which I want our Constitution to correspond. What could possibly be the problem with that? And then, of course, having opened herself wide, she gets hit from the opposite side. In that case, says the next counselor to speak, your project of aligning constitutional rights with human rights is chimerical, because there are no such things in the world as pre-institutional rights. Talk of moral rights is, he says, nonsense upon stilts. Rights are all and only what our institutions enforce effectively and observably make them. And he'd like to go on, but she cuts him off. She knows those debates too, she says, and she takes the side of what she calls moral realism. I take the expression human rights to refer to an existent real class of moral rights, she says. All I really mean by that, though, is just to say that these rights are and remain what they are, regardless of what any institutions say or do. And then there's nothing confused, she goes on to add, about an aim of having our own institutions say the things that will bring our constitutional rights into alignment with those pre-institutional rights, which are what they are, regardless of what anyone says. Which, of course, just brings on the next objection. It's not confused, says a fourth objector. It's just impossibly arrogant. You would not only have to know that these pre-institutional rights, as you call them, exist, you would have to know what they are, what is in them, or pretend that you do, in order to pursue that project. And how could you possibly claim to know any better than the next person? Before she can answer, a fifth counselor jumps in to help her out. Well, look, this next speaker says, Justitia has available the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the European Convention of Human Rights, and he goes on and he lists 4 or 5 other treaty-type instruments that have a lot of stuff in them. And Justitia can take guidance from them. And that would not be arrogant, he says. To the contrary, it would just be to suggest that our country has good reason to follow these leads from careful deliberations by highly competent thinkers from a diversity of backgrounds, but predominantly also from within the constitutional democratic tradition to which we too belong. Justitia is a learner and a person who respects serious, hard, learned prior work. But no, says the next person to jump up, that's too much of a good thing. In those 3 major international human rights instruments you mentioned, I can count more than 40 distinctly named rights. I did it the other day. You couldn't get it down to fewer than 40 if you really worked at it, and it comes out to probably more than 40. What's worse, they're all named as abstractions. Freedom of expression, privacy, fair trial, free press, a right to property, a right to subsistence, privacy, a right to work. Anyone can see, says this current speaker, that on the level of generality at which they're stated, these so-called rights are going to come into practical conflict. In order to support all of them at once, we would have to pair and qualify each one of them in some way or ways that allows for their mutual compatibility, like the pieces of a jigsaw puzzle fitting together. These instruments that you cite do qualify and limit some of their terms, but they don't really begin to solve this problem. They leave most of it open for future resolution. So if it's guidance you're looking for, those instruments don't really give us any. At this point, Justitia re-enters the conversation. I don't mean I'm going to enslave myself to those instruments and their itemizations, their lists of names, she says. There are widely discussed ways of reducing the items to a much smaller number, maybe even down to 1. Ways that are directed to an ordered conciliation among the items in the more numerous listings. And here she mentions suggestions that the one and sole ultimate human right is the right to human dignity, or to ethical independence, or it's the right to fair shares, or, as someone says, it's something called the right to justification. And then all the other named items then are going to be paired and qualified so they can all jointly combine together to do unified service to the top level right. When free press and fair trial come into apparent conflict, we work it out, cutting back on one or both of those in whatever way best serves the top level right. That's a notion, Justitia adds, that these days is often conveyed under the heading of proportionality. Each of the named rights in each concrete case is to be proportionally scaled back to the claims and demands of the others, all under guidance and control from the top-level value of human dignity or fair shares or whatever we take that to be. I don't claim, Justitia goes on to say, to have all this worked out for myself just at this moment. I'm only asking you all what objection there could possibly be to my seeing it as my job at this convention to do my best to get it all worked out and then to bend my effort toward conforming the text of our coming Constitution's chapter on rights to whatever conclusions I might reach about the composition of the true roster of human rights. But that can't work in practice. I don't know how many we're up to, a 7th, 6th, 7th counselor objects, because there's no chance that the way you work it out will agree with the way that other delegates would come to. You could never hope to get to agreement about all this in real political time. So a House rule of the convention requiring that the proposed new Constitution's list of constitutional rights is to conform to the true and ultimate conception of human rights would paralyze the convention. preventing it from completing its task of proposing a new constitution for ratification. Not a problem, Justitia responds. And she points out that the convention has adopted a good and workable set of voting rules, and they will certainly avert any danger of paralysis. Someone makes a proposal, there's a disagreement, we have a discussion, we go on for a while, and when it's time, we take a vote, and we move along. And anyway, Justitia continues, and this is going to be an important point later on. Anyway, she says, it's not any kind of house rule I have in mind, but just a rule for myself to follow, a rule to regulate my own votes at the convention by an aim of bringing our new Constitution's text on rights into as close a harmony as possible with my best understanding at the time of the true conception of human rights. I haven't yet heard what I can find a cogent objection to that. Well, those of you who keep up with debates in constitutional theory may have been noticing how Justitia is taking sides on a number of highly controversial issues. I flagged one or two, but I haven't flagged them all. But I want to make clear then, before going on, that I don't mean just now to be offering my own defense or support for all the sides she has taken. I simply want to concede them, because the question I want to address is whether there could be any further sound objection against her self-instruction, her personal rule, to push as forcefully as she can toward a conformation of the coming list of constitutional rights to human rights, after we concede to her on all the issues posed so far. And what I want now to suggest is that the answer could depend on what sort of function the Constitution is expected to fulfill in the life and affairs of the country, whose Constitution it will be. Pause. Take a drink of water. A country's Constitution is typically meant to serve, we can call it a legal normative function. That's a function of laying down certain basic laws to control the subsequent operations of the state and all subordinate lawmakers. We're all aware, too, of how constitutions can serve an expressive, or has sometimes been called an integrative function, representing to the country's people and to the world, by the ideals and commitments it contains, the grounds of this people's special identity and unity as a people. I see nothing. I, from here on in, is I, Frank, not I, Justitia. I see nothing in either of those functions that should stop anyone from aiming to have their country's constitution conform to whatever human rights there really and truly are. If there are human rights in which you really and truly believe, how could you possibly not prefer that your own country's highest laws should affirm them? That's the question. Now here we go. I'm thinking, it's making me think of the Seder that we just went through a week ago. The 4 questions have been asked, and here we go. I now introduce for consideration an additional sort of function or service we may expect from a country's constitution. And that's the function of providing a public platform for the legitimation of the country's regime of law. This is going to require a bit of explanation. By the term legitimation, I mean the social communicative processes by which a country's people sustain among themselves a sense of the assurance of the overall deservingness of their political regime in force to continued and general regular support. Even as they may also be confronting facts of widespread doubt or disagreement, some of it intense, about the justice or wisdom of this or that law or combination of laws. Legitimacy sets a kind of minimum floor of decency for a state, above which citizens can maintain their sense, but below which they would lose their sense of a moral license to call upon each other to carry on with their willingness to support the state and abide by its laws. Legitimation, thus, has both sociological and justificational aspects, inextricably intertwined. As a sociological matter, a matter of the facts on the ground, a failure of legitimation threatens political disintegration. But that's not all it does. A failure of legitimation furthermore strips the country's citizens of recourse to reasons all can accept for a regularity of compliance with that country's laws by everyone, by each other. And for a people, I'll call them, broadly speaking, liberal people, a people who prize each person's full and equal claim to freedom and to moral capacity and responsibility, such a failure is no less a mutual moral than a mutual practical catastrophe. Legitimation is a matter not simply of securing a regularity in fact of people's submission to the state's authority, but of sustaining across the society a joint assurance of merit in the state's claim to an authority that is acceptable on terms and for reasons, and here I'm quoting from a certain well-reputed liberal political philosopher, on terms and for reasons that all citizens as free and equal may reasonably be expected to endorse. Citizens in a democracy know they're fated to disagree intractably over the ultimate rightness and goodness of the state's policies as adopted and pursued from time to time by law. But then they see that they, collectively, if they want to hold their common political project together on terms of mutual reasonability and civic reciprocity, have need for a commonly recognized standard of legitimacy, one that each can cite to the others in good conscience. And that's where the Constitution comes in. The Constitution, on the theory of constitutional function I'm just now expounding, is to figure as something like the country's public charter on legitimacy, its public platform on legitimacy. Now, let me be clear on one point. It's not necessarily the case that a country relies on its body of constitutional laws to supply this very important function of providing a public platform for legitimation in that country. Whether it does so or not is a question of social fact, which can vary from country to country. And I must leave it to you to consider whether it's a true fact about whatever country or countries you might be most concerned about. But I do ask you to assume that this fact is true of some countries, because the rest of what I have to say applies specifically to countries where it is. Speaking now of such countries, if the citizens find that they have in force a good enough looking constitution, then that is what allows them to feel justified in calling on everyone else for compliance with the state's laws that are found to be compliant with the terms of that constitution. So here's how it works. Doubts arise about whether some state law or policy really does conform to justice and human rights. I can use an example, so I'll take a current hot-button topic of debate. Shall we or shall we not have a law requiring shall we or shall we not have a law requiring service to all comers by commercial vendors of goods and services, florists and bake shops not excepted, regardless of religion-based objections? There's no escape from answering. We either will or will not have such a law. Not having it is no less a political choice than having it. Either answer will be met by heartfelt disagreement of a kind that arguments back and forth will not resolve. We might be able to resolve the question of constitutionality of one choice or the other. We are not, by the force of the better argument, in real human time, going to get people to come to agreement on the truth, the moral truth, the human rights truth, the justice truth of this question. Where the Constitution is serving as a platform of legitimation, the practice will be to deflect those disagreements to questions of constitutionality. The appointed arbiters of constitutionality, they'll be different in different countries. We know who they are in the United States of America. The appointed arbiters of constitutionality will decide whether the choice made politically is allowed by the Constitution in force. Note that it is emphatically not the same thing as deciding which choice is really and truly the one preferred by justice or human rights. It's just which It's just about whether the choice that the political system has made for the time being is allowed by the Constitution. If the arbiters answer yes, then those opposed are expected to comply for as long as that political choice remains the law. That plainly can be a very important function for a constitution to serve. Not just a practical, but a moral function, as I have started to insist and will be insisting throughout. Now, obviously, not just any old constitution will be good enough for work of this kind. In order to be good enough, in order to be, as we might say, a legitimation-worthy constitution, it might have to include assurances that certain rights and freedoms will be respected, indeed will be protected by the state against undue encroachment by others. In order to carry the weight of legitimation, then, the Constitution would have to include a mention of each and every one of those guarantees required for legitimacy. Referring to our prior example, those might, or they might not, include a clause on the free exercise of religion or on the protection of law-abiding people against harms of exclusion from daily places and activities. But note then also, as this very example suggests, that a legitimation-worthy constitution will also have to meet what I'm going to call a Goldilocks condition. It must be good enough, but also not too good. Big enough, but not too big. Hot enough, but not too hot. That is to say, it must not be so thickly stocked with rights as to defeat the wide acceptability befitting a purported public contract on legitimacy. So say the Constitution's list of rights is pretty long. South Africa has 34. I think I've counted them. I come to something like 34. Say it includes dignity, equality, liberty, fair trial, expression, press, association, culture, religion, property, work, subsistence, education, and health. And by the way, all of those can be found in the major international human rights instruments that I mentioned before. Avid supporters of some of those items will have reason to be wary or even hostile about the inclusion of some of the others. Those who place great store by culture may feel impelled to reject equality, and vice versa. Think that one over. I can cite you major historical examples. Look in the Israeli Basic Law on human liberty and dignity and see where's the equality clause. It's not there, and it's not there by accident. So those who place great store by X are going to feel impelled to reject Y. And so how do we hope to achieve the wide acceptability to everyone required for a viable public platform on legitimacy? Puzzlements of that sort have led some liberal thinkers to lower the legitimacy floor well below their own ideal conceptions of the rights to which any state ought at all times to be committed. Lower it, say, to a point where the floor is satisfied as long as there is some core guarantee against arbitrary arrest and punishment and some core space allowed for freedom of political association and expression. And maybe there's also something that has been called a decent consultation hierarchy. A list that does not come near satisfying anyone's conception of human rights who talks about human rights at all. We don't have to go that far, though, to see how your insistence or my insistence on inclusion of what you or I most sincerely takes to be the true full roster of human rights could press a constitution beyond the Goldilocksian breaking point of legitimation worthiness. Now, when I first, some months ago, began putting these thoughts together, I worked alone for quite a while with the idea that this would be the danger with involving enthusiasts for human rights in the work of constitution writing, that they would feel impelled toward overstuffing the legitimation platform with too many items, in disregard of the moral need of fellow citizens for a constitutional platform that all could reasonably call on all the rest as free and equal to endorse, as giving everyone sufficient reason to take their chances on the policy choices that might issue from a politics conducted under this minimal set of guarantees. But now, in the course of working through our exchanges with Justitia, I've come to see matters in a different light. The problem, finally, as I now see it, comes down to something more like the opposite of what I had thought. It is that the true believer in human rights that are pre-institutional, rights that are what they are regardless of what any country does or does not see fit to write into its laws, will have to stand opposed to inclusion in the Constitution of any items whose presence there looks primed to be a cause of future normative disorder in the resulting future political and legal practice. And Justitia's personal rule, her rule for conformity of the Constitution's chapter on rights to the normative order of human rights, can thus lead her to oppose inclusion of some items that, as I will argue, she ought morally to accept in deference to the shared moral need of everyone for a legitimation-worthy Constitution. So, come back with me now to Justitia's response to the objection of intractable disagreement at the convention on the qualifications on each of the named rights that would be needed to order them into a workably coherent normative totality. She answered by pointing to philosophical expositions of human rights conceptions that are unified under a master value such as dignity or fairness or equality of respect, or your favorite, where all the other commonly listed items are then to be understood merely as reminders of human interests and needs that need to be kept in mind, but all of which will remain open to proportional reciprocal adjustment as the processes of application and learning proceed into the future. And what I now want to emphasize is that that's how, well, no, I don't need. Yeah, what I now want to emphasize is that's how anyone would have to answer while professing belief in a pre-institutional order of human rights. Rights multiply named cannot all be pre-institutional, cannot all claim to be what they simply and truly are, regardless of what anyone ever actually does or doesn't do about them, unless they do indeed compose together an order unified, consistent, and stable. The human rights true believer, then, far from wanting to load up the Constitution with 40 listed items or so, will incline strongly toward keeping the item on rights few and abstract. She'd want to include, of course, an item that named adequately whatever she takes the mastering order value, say it would be human dignity, and after that, no larger a number of additional items than a unified, consistent, and stable ordering of civil life and affairs under the guidance of that master value could tolerate. So Justitia is going to be on the lookout at the Constitutional Convention for what she calls monkey wrench items, items that will screw up the works if you put them in. So, how about a clause on liberty of conscience? Liberty of conscience. Justitia should have no problem with that. Of course, it's obvious that individual consciences cannot be guaranteed to respect the equal rights of others. People can conscientiously be moved to all sorts of civil misdeeds. Precisely for that reason, though, because it's so obvious, Justitia can confidently foresee that claims brought under an abstract constitutional rubric of liberty of conscience inevitably will be treated as matters of relative moral urgency, subject to proportional accommodation in context to coordinate moral demands coming from free and equal others. That will hold, for example, in the case we've already mentioned, where a business person's conscientious aim to avoid commercial contact with a civilly innocent activity that contravenes the tenets of her religion, runs up against the claims of members of an historically excluded social group to non-degraded access to the normal arenas of social life. What gives comfort to Justitia is not an expectation that the business person's claim of conscience will necessarily lose out, but rather, under a rubric of liberty of conscience, will be treated as no less submissible than other claims of conscience to the demands of a continuing pursuit of a generalizable normative order of human rights. Now, what about a proposed clause on free exercise of religion. Justitia may find herself thinking that she has to oppose it. Such a clause will be headed for trouble, she may think, because in her society, the term religion resounds with organizational and outward performative dimensions that conscience in the abstract does not. Religious profession, as Justitia knows her society to understand and cherish that idea, can essentially demand of the faithful a socially visible conformity to ritual codes. It can demand a visible embrace of norms of behavior that might clash with those of civil society at large. Religions can be missionary and militant. Religious attachment can motivate demands and pressures for a supportive, like-minded social surrounding to the detriment of the freedoms of other people living there. And all of these in ways that the simpler notion of conscience does not essentially involve. Justitia would not suggest that all of these, or any of them, are aspects of any possible religion or of religion just as such. She does, however, perceive that these dimensions of some religions have distinct and positive values for many religious people in her society. Justitia thus further perceives, or thinks she does, that these organizational and externalizing dimensions compose at her convention a part of the motivation for proposals for a constitutional clause on religion. The religion clause, she notices, would come on top of, in addition to, abstract clauses on liberty, conscience, belief, expression, and association that everyone is ready to accept. Justitia thinks religion's claim to fair consideration is sufficiently covered by those other abstractions, to the extent that the term religion might more concretely suggest some additional and special organizational and performative exemptions beyond what those others would provide, a kind of extra consideration for religion. As Justitia would be seeing it, she sees a religion clause in the Bill of Rights as primed as a likely troublemaker for the future equipoise of the normative order of human rights in her country. Now, these perceptions on Justitia's part regarding the motivations and effects of a proposed constitutional religion clause might be mistaken. The fact is, though, that she holds them, and that they, combined with her personal rule to align the Constitution's Bill of Rights with the true order of human rights, could lead her to oppose inclusion of the religion clause, and I want to finish these remarks with the suggestion of a moral objection to her taking up such a position. I think she's in danger of making a moral mistake. Legitimation, we have to remember, is a matter of political sociology no less than of political morality. What it takes to make a constitution legitimation worthy cannot be learned by moral speculation alone. It has to be learned in part from the situated exercise of a political sensitivity informed by moral capabilities of civility and reciprocity. Such an exercise could well suggest the presence of a moral hazard in a demand to suppress religion from the Constitution, leaving conscience unmodified to carry the load. It's not, after all, as if religion is antithetical to conscience. To the contrary, religion must be allowed in a society like ours to figure as a concretization of the abstraction named as conscience. Without some such concretization drawn from people's own life experience, and perhaps also from a people's historical recollections, the abstraction could never gain or credibly claim a decisive weight in a here and now deliberation over the basic terms of civic ordering. Conscience just doesn't say enough to people. You don't get it until you associate it with something in your life that matters to you. And for very sizable numbers of people in Justitia's country, that's something, that first and foremost thing, is going to be religion. Wonder not, then, if a substantial fraction of Justitia's fellow citizens insist on a religion clause as an essential component of a legitimation-worthy constitution for their country. Wonder not if they refuse to shave religion clean of those features of performativity and outward engagement that cause Justitia to see an item on religion as potentially a distraction from the pursuit of the true, pure conception of human rights, but which for substantial numbers of her fellow citizens are indissoluble from the rest of what places religion for them at the core of conscience. We can assume these are social facts comprising a part of Justitia's situation. She cannot reasonably or credibly put them down as beyond the pale of civic reasonableness. John Rawls himself, and John Rawls, as some of you doubtless will have perceived, has been a major inspiration for these remarks of mine this afternoon. There's my coming out remark. Could find no way to expound to his expected readership his own conclusion in favor of liberty of conscience as the first and foremost liberal constitutional essential, except by largely collapsing conscience to religion in the pages he devoted to this topic. Rawls's own work thus stands as testimony to the civic attraction of a claim to a special safeguard for religion in the pursuit of a legitimation-worthy constitution for his own historical time and place. Rawls thus testifies to such a claim's good standing as a part of the moral imperative among free and equal citizens cohabiting a social world to seek and to find in the here and now the terms of acceptance of the exercise of political power and the force of law. By presuming for herself a rule that could bar her from acceptance of any such claim, Justitia pro tanto demotes and disregards that moral imperative. That's my critique of her. She's being a good moralist. She's not being a good citizen. Now, you then might feel moved to respond in the following way. Human, you might say, outranks citizen. The imperative always to strive toward the end that human beings are treated with the respect and regard due to human beings takes precedence over obligations to fellow citizens to treat them with the respect and regard due to fellow citizens. Human outranks citizen. Justitia, you might say, cannot be subjected to criticism for observing that priority, morally stressful and painful as that might be. Such a defense of her will not work, however, for any among us who might think that being a citizen, which already means, of course, being a fellow citizen, is integrally within our form of life a part of what it means to be a human being. So I end with a little Aristotle, even though it was mostly Rawls along the way. Thank you very much. Do you want me to just, okay?
Floor is open.
Thank you for your talk. That was very interesting. I was wondering, you talked about your concern initially that Justitia would be trying to pack all of these rights into the Constitution, and then you realized that actually maybe.
And I turned it around. Yeah.
And I'm wondering if if it might actually be good to pack more rights in there for the reason that you kind of talked about of your example with the Indiana law.
Yes.
So that there are a number of different rights at play, and then when we go to have a political discussion, sides can draw on these different rights and have, I guess, political argument. So that's what we do. So if we want to add more rights, do you think that's a good way of sort of balancing out what we fear that we might have?
That's a great question. That question really catches on, I think, to what's going on in this paper. So thank you for it. I think you're on the right track. and it's, of course, the direction, the track I was on when I ended, from reading Justitia as wanting to put too much in, I turned around to read her to want to take too much out. That means put something more in, if you want it to be legitimation worthy among free and equal reasonable citizens in the time and place where you are. Let me mention, I think it would be helpful if I mention here some work that's being done by a Canadian constitutional theorist by the name of Gregoire Weber, who's writing about what he calls a negotiable constitution. And by the negotiable constitution, Weber has in mind something like Justitia's, I think, perfectly sensible vision, that the writers of the Constitution can't go beyond the level of abstraction. Abstractions at a level that don't answer the hard cases. They don't even know yet what the hard cases are going to be. They haven't foreseen the florist who's unhappy about having been invited to provide services for the wedding. And his idea basically is the Constitution is not finished at the time when it is adopted by the plebiscite or whatever. It remains to be fleshed out. It remains to be filled in. It remains to be negotiated, right? I think that's a basically right idea. I think that if a body of citizens could get that idea firmly implanted in their heads as a body, it would make for a better political situation than the one that we presently encounter in our country. What I have done in this paper, Weber has in mind a few abstract clauses, right, that then will be filled in with subclauses as learning and experience make that possible. I'm just adding one little footnote, in a way. I'm saying, it's not just a question of filling in blanks. It's a question of paring back the meaning of items that are already down on paper. The way to approach the constitutional negotiation, and this is what I take to be the spirit of your question, one way to approach constitutional negotiation is not to write one at all and just leave it to the courts and the Congress, in the future to sort of work it out. That won't provide the legitimation platform that we need at all. It won't do the work. Another way to seed a constitutional negotiation is to fill the Constitution up with so much stuff that it's obvious from the beginning that it can't all be applied, that they can't all be applied to the outer limit of their dictionary scope. There'll just be contradiction all over the place. So it'll be obvious that the negotiation is going to be bidirectional. The negotiation in part is going to fill in blanks that were deliberately left. And what it's in part going to do is to qualify print that was put in there in the expectation, as everybody foresaw, that the learning, the situational experience and wisdom and so forth required to get the correct qualifications, adjectives and adverbs into that text would be waiting for the future and would be part carried out not above politics, but in and through politics, right? So yeah, your long answer could have just said yes. Just to be sure I hear you, please speak up.
So I'm not sure how to articulate this question. And it's a brilliant work, of course, and we're proud to have you here. There's something I'm trying to figure out how to articulate with regard to the difference between a right of religion or conscience from other rights that might appear on your list. It strikes me that if we think about privacy or the right to subsistence or the right to work, it's a right that, in a Rawlsian sense, everyone would would agree to behind a veil of ignorance, perhaps, because it's a right that's fairly equally shared. The thing that I'm trying to figure out, though, there's something different about a right of religious exercise or conscience, because it gives individuals the right to a waiver of what from otherwise regulatory obligations, and that the waiver has the exact same contours that each individual brings to the exchange. And so I'm not sure that if the test for a right is a right, the legitimation question, whether it's something that everybody would agree to among equals, because it's the very nature of the right is a right to be treated differently from others. And so
I've got it.
I wonder if that's a puzzle.
Yes, as you stated, it's a puzzle, and I'm going to what I'm going to offer by way of a response is one proposal for a solution, which I draw from John Rawls. What your question does is it moves us back a stage from the Constitutional Convention to the original position. The Rawlsians will, if I mention the four-stage sequence, Rawlsians will know what I'm talking about. You're talking about the principles of justice on which you could expect people to agree if they were engaged in something like a constitutional convention, but with a lot less knowledge then about their society and the future and their likely position in the society and so forth than constitutional conventioneers would normally have. And Rawls, there's no doubt, I've recently written on this, and there's no doubt at all that Rawls comes up with two principles, and the first principle has priority, a strong priority over the second principle. You have to fulfill the first one before you can go to the second one. The right to work that you have in mind, if it's appeared at all, would be in the second principle, not the first. The first consists of a list of mainly what we would call the mainly negative defensive liberties. And the first one, the first and master item is conscience. Now that to you is a puzzle because conscience doesn't look equal in the appropriate way. Conscience seems like a claim to privilege in some way. So I think what Rawls would say to you in response is, first, how can you not? How could a people possibly agree to form a political order in which they know they're exposing themselves to be bound by an obligation of fidelity to laws that will sometimes be made over their opposition, right? It's majority rule, but you're not always in the majority, and some laws are bad and they're atrocious. They need some protection. They will feel they need some protection, and if you ask them what they need protection for, say, my moral self, my self-determination. Dworkin calls it their ethical responsibility. You say that's a problem. And I tried actually to note in my paper at one point about the problem. Because conscience can tell you to do anything. To use Ronald Dworkin's metaphor, conscience can tell me to swim in the next lane over so as to defeat the competitor in the race. So what Rawls does is this. He formulates the first principle of justice, not as a list of basic liberties. He doesn't say, the following are the basic liberties: conscience, expression, security of the person, so on. He says, the principle is that each person is entitled to an equal scheme of equal basic liberties. We all are entitled to liberty of conscience under a scheme that treats us equally. So equality is built in at the very most basic foundational level in this conception. People who sign up for freedom of conscience are not just signing up for their own. I'm signing up for yours. I'm signing up for the conscience of that florist. I'm signing up for the conscience of that couple who want to marry and do so in conditions of full dignity and acceptance in society. Scheme. Rawls's scheme is like my paring back so that the things accommodate and add up to a unified, stable, coherent whole under a leading value. And although Rawls is sometimes described as a rights rather than an equality-based theorist, I myself have a problem with that description for the very reason that I've just put to you, that the rights, no rights come without equality, as it were, ahead of them, modifying them. All rights are equal. And every claim of a right is a claim on behalf of the next person's claim to the same right as the one you are claiming. Now I say, that's what, I said I would put before you one proposal for a solution. That's the proposal. And my paper echoes it in a way, but it's a little different, because what I basically have said is, well, it's not, I don't know how different it is. The claim of conscience will be, the claim of conscience will be respected as such, but it won't necessarily be granted, because there are other claims of equal dignity. I won't say of equal weight, but there are other claims of equal dignity also on the table. And they can't both be fully granted. And so something will have to give. And that's where this form of artistry called proportionality is supposed to come in and solve the problem. But what we're really talking about is political wisdom and sensitivity and civility of a certain high-order kind, which may be beyond human reach. Catherine.
Yeah, I find your concepts really helpful, so thank you. But I get very confused when I get to the piece where we're going to situate it, and we're going to look at the sociology. On the one hand, we want it to serve a justificatory function. On the other hand, we have to recognize that the justification will only work if it fits into the sociology of the people that will be living with this Constitution. And so at that point, I followed you thinking about maybe what our Constitution should look like. But I'm wondering, what would a Constitution look like if you lived in a nation of Emersonian transcendentalists? Or what would it look like if you lived in a country where most people wanted to follow Sharia law, but there were large portions that didn't? So it seems to me there's a lot of
all right, well, the Sharia law case looks different to me than a lot different to me than the Emerson case. The Emerson case, the Emersonian case is just, they put in conscience, right? They put in thought. The Emersonians, they have freedom of thought in their constitution. They don't put in religion. And maybe that may be a quite conscious and deliberate choice if they're, though, if you ask whether Emerson himself was religious, it's a very hard question. It's a very, very hard, taken as a biographical question, it's almost impossible to answer, so far as I'm aware. So what will happen? If it's if this process of negotiation is going on, if and as if and as Massachusetts becomes populated with people who are religious in the sense that Justitia envisions, and whose religious consciences are outward looking, right? So that how I visibly conduct myself, what takes place in my neighborhood with my tolerance and acceptance, become questions of conscience. Then, there are various possibilities. If the Constitution were sensibly open to amendment, I could name a couple. One that's not. We could have a constitutional deliberation about this on the kinds of terms that I've been trying to express. If it's not, then claims will come to court under the rubric of conscience. And they will be met with the objection that there's conscience on the other side of the encounter, on the other side of the conflict. That won't necessarily defeat the first claim. It won't necessarily endorse the first claim. It will open up a next chapter in the negotiation of the Constitution. The key notion here is that contrary to what that the legitimation function of a Constitution requires, I said, that it not be too hot or not be too cold, not be too much, not be too little, also not be too fixed and not be completely open. I don't want to say not be too open because I'm not sure that there'd be any such thing as being too open, but it can't be completely open. There has to be some fixture or it's not doing anything. You say, you can sign up for government in this democracy because you've got that. And they look at that and they say, but that just says boo, right? It has to say something that's a point I was trying to make when I spoke, that connects with their lives and experience. So there has to be some fixture. But there has to be a lot of openness. And that kind of openness, I think, is not well tolerated. Not well tolerated by long-established political habit and a great deal of our legal theorizing, a great deal of our most fundamental legal theorizing. I don't mean just the United States, but in the family of societies of which we're a member. Yes.
Hi, Professor Lockman. Thanks for your presentation. It's an enriching presentation. I've learned a lot from it. And I guess I want to follow up on your answer to Kent's question.
Okay.
And it's about prioritization, how we prioritize
Yeah.
the significance of rights. And one of the things I enjoyed and learned a lot about during your presentation was the way in which you regard the value of entrenchment. As I understand you, there are maybe three reasons why we entrench. One is the protective function. We're protecting what it is we're entrenching. We need political enforcement, but the Constitution helps.
Yeah.
Two, there's an expressive function.
Yes.
We're entrenching something because we want to tell people that we care about this thing.
Right.
And then finally, third, and this connects to Craig Law's point, there's a catalytic function.
Yep.
We protect something, we entrench it because it will encourage political actors to engage with one another, to shape the contours, but also the content of that thing that we have entrenched. Now, when there is conflict between or among rights,
Sorry, Rick, I didn't get.
when there is a conflict between or among rights, a
Yes.
collision, how do we determine which one takes priority? As I understand the basis of the South African Constitution, to which, of course, you were involved, this is an effort to universalize rights.
Yeah.
But this is not the kind of approach that governs around the world, for example. So I wonder if you would accept the following proposition, that domestic constitutions can adopt different hierarchies of constitutional values that may in fact be in conflict one with the other across borders, but that you leave to the people themselves to decide what it is about their particular constitutional order that merits greater solicitude than other protections.
They can adopt different orders of values. As an empirical statement, that's true, but you meant it, that they have moral permission. Well, how far do you want me to go down the track of ditching Justitia?
I haven't met her.
She's pretty good person, I think. If you think that there's a pre-institutional order of political morality, then that moral permission is limited. It's not closed. It's not closed if you, I say it's not closed because I take the last paragraph or two of my paper seriously. I think that you cannot hierarchically rank the instincts or intuitions, you cannot hierarchically rank moral universalist convictions or intuitions vis-a-vis civic or civil obligations. You cannot say, that's just against the universal moral law and we can't have it here. You might reach that conclusion. And someone says, but we need it here because a part of the moral law that we're trying to work out here is a law of civility in relations among citizens, where citizens respect each other's claims for a need of a common public basis of justification of the exercise of non-unanimous political power. And it does turn out that nations are different. Peoples are different. Histories are different. And so my argument is, there's I think I'm totally Rawlsian about this, by the way. Not necessarily what you read in a theory of justice, but certainly what you read in political liberalism and law of peoples. If civility is a part of morality, if respect for the claims and needs of those with whom you share a social space and upon whose cooperation and goodwill you depend for your life and everything else of value to you, if that's a part of morality, then we have a dialectic here. It's a structure. It's a tension, and there's got to be space. There's got to be space and allowance for. The word compromise was coming to my mouth, but then there are certain philosophers who use compromise in a way that would make me not want to put it right into this particular context. But latitude, risk-taking. If you think of it from the standpoint looking forward from the original position, then the problem isn't soluble unless every participant is prepared to shoulder some share of risk that things won't play out in the future. Not only not exactly as he or she would want, but really close to what he or she would want, as long as the worst catastrophes are guaranteed against. So I guess what I'm saying, civility involves risk. It involves leaving things open in the hope that they will be worked out correctly and in the understanding that they will not necessarily be worked out correctly.
Maybe Vlad has the last question.
Do you want to preempt Katie?
Oh, not at all.
No.
Go ahead.
Professor Young, go first. Then Professor Perdue.
Well, I'll make mine brief, but my question was really the way in which you are talking here about pre-institutional human rights and what it does to the argument to talk about institutionalized human rights.
Yes.
given that so many have been institutionalized over the last 2 centuries, and we could say that there has been a lot of consensus reached in different places,
Yes.
not simply in the covenants and the Universal Declaration, but in constitutions around the world.
Yes.
So it points a little bit to the last question, but Justinia could find some solution perhaps in having the proposed constitution have a requirement of reasonable consideration of the meeting of pre-institutional human rights into institutions around the world.
Okay, now, I mean, yes. I could take a guess about where that's coming from. Maybe the Constitution could say, instead of a Constitution saying that a court may consult foreign law or foreign international law, it might say a court shall consult foreign and international law. Human rights law, or whatever. Should she have a problem with that? Well, no, I would. She'd want the historical record to make clear that consult does not mean feel obligated towards, right? Learn from, right? She's willing to concede some degree of epistemic authority to the bodies that promulgate these ideas, but no political authority. None, zero, I think, would have to be her position. And that, by the way, there's a third factor here, too. It's not just that she might concede on epistemic grounds that consulting is a good idea. And there might sometimes be political or legal or contractual grounds on which consulting is required because it's a treaty and the country has signed up. There's a third category, I think, that I don't know what the name for would be, collaborative grounds. That the project, within the limits of what morality permits, the project of conforming the practice of rights in your own country to what is recognizably being followed elsewhere can lead to goods of amity, friendship, peace, coordination, mutual understanding, cooperation, and so forth. And those too could be taken into account within the bounds of the kind of morality that I'm thinking about.
Professor Pedro has the last question.
Just to channel my inner Hans Kelsen, I think that, so the Kelsenian challenge to your argument would run something like this. It is a mistake to step outside the normativity of law. Stepping outside of the normativity of law endangers stability for the kind of stability for the right reasons, the kind of social order that you are very much concerned with.
Right.
And you don't need to make that step. The normativity of law, properly understood, has within it everything that you think sociology needs to provide. So you can think of the ways in which Justinia rejects sort of you can take this lens and you can apply it at various steps of the argument that you have made. It is certainly possible to say that the moral mistake of rejecting the religion clause sort of overlooks the sociological dimension, the fact that conscience just is not enough because people do not recognize themselves, do not be collectives of government. And then the normativity of law would say, well, think harder, recognize yourself in conscience, go through that learning process, which itself can be understood as part of the normativity of law in a constitutional democracy, to think harder. Because if you do not think harder, you run into exactly the problem that you have emphasized during the second half of your remarks, which was sort of the normative destabilization potential of sort of overly.
Right. The phrase that comes rushing to mind as I think about how to respond to you is "in principle." When we're talking about civility, when we're talking about a posture, an attitude that one ought to take up in relation to civic affairs, where one is dealing with other persons qua citizen, right? not qua philosopher, not qua exceptionally capable, exceptionally theoretically and analytically capable and clear-sighted thinker, but a person of goodwill, presumably of goodwill, who carries about with him or her the same spirit of reciprocity that you are trying to enact on your own behalf, but who is, to some extent, to the normal extent, a creature of her experience. There's a limit beyond which, it seems to me, we can't ask her to think things through, to the depth at which a Hans Kelsen was able to do. I don't think of Hans Kelsen as, the word, if I want an adjective, if I want a synonym or a descriptive noun for Kelsen, the word citizen is just not going to be the one that rushes first to my head. Jurisprudence, philosopher. So that's about the best I can do. So I have an instinct against falling back to conscience on the ground that sooner or later everybody can figure out that they are reflected there. And I come back actually to the point I made in my paper. When Rawls saw that he had some necessity to convey to his readership what it was all about, that everything is about religion. That was his concretization. If it was his, how can we deny it? How can we deny it to ordinary people? And the Constitution has to be made, in some sense, has to be made for ordinary people, I guess. That opens up another huge chapter, of course, in the debate between legal and juridical constitutionalists and popular constitutionalists, but we can do that the next time.